So picture this, you're jolted awake at 4:30 a.m. by the sound of shattering glass and a deafening boom. Smoke from a flashbang grenade fills your hallway. Before you can even process what's happening, strangers in tactical gear are screaming at you, blinding you with weapon lights while your spouse is held at gunpoint. You're terrified, confused, and convinced these are home invaders, only to realize they have FBI emblazoned across their chests. Then comes the oh crap moment. Not for you, but for them. One of the agents looks down at the mail on your coffee table and realizes the address doesn't match the warrant. They're at the wrong house. The actual target is 3 doors down. They leave. They offer a half-hearted apology, maybe a business card, and then they disappear into the night to go raid the correct house, leaving your front door in splinters and your 7-year-old son traumatized. Now you'd think that in a country built on the Fourth Amendment, you'd have a clear-cut case to sue for damages, right? Wrong, because when this family tried to hold the government accountable, the government looked them in the eye and said, actually, you can't sue us. We decided to use a personal GPS and we decided to ignore the street signs, and since those were choices, we're immune from the consequences. Today, we are diving into the critical case of Martin versus United States. We're talking about a unanimous 9-0 Supreme Court ruling that just sent shockwaves through the Department of Justice, and why every single American needs to understand the shield the government is trying to use to stay above the law. But here's the thing. Even after a 9-0 smackdown by the Supreme Court, the federal government is still fighting to prevent this family from ever having their day in court. The story starts in a quiet suburban neighborhood in Atlanta back in 2017. The FBI was planning a pre-dawn raid. Their target was Joseph Riley, a suspected violent gang member. They had a warrant for 3741 Landau Lane. It was a high-stakes, high-risk operation. Now, pre-dawn raids are already controversial enough on their own. You're talking about federal agents storming into someone's home in the middle of the night when people are most vulnerable, most disoriented, and least able to understand what's happening to them. But here is where the operational screw-up begins. The lead agent, Special Agent Lawrence Guerra, didn't use a high-tech government navigation system. He didn't use the address written on the warrant itself. He used his personal GPS. Even though he typed in the correct address, the GPS routed him to 3756 Denville Trace, the home of Katrina Martin, her partner Toy Cliat, and their young son, despite the fact that the street name was different and the house number was clearly visible on the mailbox. The tactical team followed the GPS blindly. Not just a different home in a different neighborhood. We're talking about a house that was only 3 doors down from the actual target address on the same street. This was a completely innocent family that had absolutely nothing to do with gang activity, nothing to do with criminal enterprise, nothing to do with whatever the FBI was investigating. They were just ordinary citizens living their lives. What followed was a nightmare. Without any warning whatsoever, a 6-member SWAT team breached the door and detonated a flashbang inside the house. Now, if you're not familiar with flashbangs, these are devices that produce an extremely loud noise and an intense flash of light designed to disorient and temporarily incapacitate people. They're used in tactical situations to shock and confuse suspects, and the FBI was deploying them inside a home with a 7-year-old child. Katrina Martin and her boyfriend were hiding in a closet when the agents burst in. The boyfriend had grabbed a shotgun, which, by the way, is exactly what any reasonable person would do if they thought armed intruders were breaking into their home in the middle of the night. They dragged Toy out of the closet and held him at gunpoint. They handcuffed him. She was half-dressed at the time. Imagine that level of terror, that level of humiliation, that level of violation of your most basic sense of safety in your own home. The agents also pulled a 7-year-old child out from under his covers, a young boy who just watched heavily armed federal agents storm his house, detonate explosives, and hold his mother at gunpoint. It was only when Agent Guerra saw the mail on the table that the raid came to a screeching halt. There was some mail sitting there with a different address on it. And that's when they realized what had happened. That's when they had this huge oh crap moment. The bad guy wasn't there. They were in the home of an innocent family. So what did the FBI do at that point? They let the family go. They told them they would be back soon to explain what happened. And then they left the Martin home, walked 3 doors down the street, and raided the correct house, the one they were actually supposed to target in the first place. Think about that for a moment. This family's entire life was turned upside down. They were terrorized in their own home. Their sense of security was shattered. Their child was traumatized. And the reason? Because a federal agent relied on his personal GPS instead of following the address on the warrant. Now, before we get into how the lower courts actually agreed with the government and how the Supreme Court had to step in, if you want to support this channel and keep up with these critical updates on your rights, one of the best ways to do that is simply to subscribe. click that notification bell so you don't miss the next update, because the government is currently trying to bypass the Supreme Court's ruling as we speak. To understand why this family has been fighting in court for years, you have to understand the legal framework that governs when and how citizens can sue the federal government. Under normal circumstances, the government and individual federal agents are shielded from lawsuits through something called sovereign immunity. This is an old legal doctrine that basically says the government can't be sued unless it consents to be sued. Usually, the United States government has sovereign immunity, which is a fancy legal way of saying you can't sue the king. But in 1946, Congress realized that if a mail truck hits your car or an agent tramples your rights, the government should pay for the damage. So they passed the Federal Tort Claims Act, known as the FTCA for short, to waive that immunity. This law allows ordinary people to sue the federal government for certain wrongful acts committed by federal employees when those employees are acting within the scope of their job, and Congress specifically amended the FTCA to include something called the law enforcement proviso. This is a special part of the law that Congress added because they knew law enforcement officers have a unique power to violate someone's personhood. It specifically says you can sue for things like assault, battery, and false imprisonment when committed by federal agents. Congress recognized that law enforcement has enormous power over citizens, and there needed to be some mechanism for accountability when that power is abused. However, the government left itself some massive loopholes, and the biggest one is called the discretionary function exception. Think of it like this. If the government makes a high-level policy decision, like how to allocate funds for a highway or which neighborhoods to prioritize for patrols based on crime data, you can't sue them just because you don't like the decision. That's discretion. The idea is that courts shouldn't be second-guessing policy judgments made by government officials. If an official has discretion in how to do their job, and they make a choice within that discretion, the government is shielded from liability. Now, that might sound reasonable on the surface. We probably don't want courts micromanaging every policy decision made by government agencies. But what the government argued in the Martin case was that everything is discretion. They argued that the agent's choice to use a personal GPS and the team's choice of which door to kick in were discretionary acts. Basically, they argued that because they had the choice to get it wrong, they can't be held liable for the mistake. The government has been using this discretionary function exception as a shield to avoid accountability for basically everything, including situations that have nothing to do with actual policy judgments. After the dust settled and the Martins realized the psychological toll this raid had taken on their family, especially their young son, they did what any American should be able to do. They filed a lawsuit. They sued under the FTCA, specifically citing the law enforcement proviso. To the Martin family, this was an open and shut case. The agents had no right to be there. Therefore, the detention was false imprisonment, and the guns in their faces were assault. But when the case hit the district court, the government's lawyers didn't argue that the raid was right. They argued that it didn't matter if it was wrong. When the Martin family filed their lawsuit, the FBI immediately moved to dismiss the case, their argument, that the lead agent had discretion in how he prepared and executed the pre-dawn raid, and therefore everything that happened, including raiding the wrong house, fell under the discretionary function exception. They invoked that discretionary function exception we talked about. They told the judge, look, Agent Guerra had to make a choice on how to navigate to the target. He chose a GPS. He chose a route. These are choices involving professional judgment. The agent's decisions about how to conduct surveillance, how to navigate to the location, and how to approach the house in the dark all involve discretionary judgments. Let that sink in for a moment. The FBI was arguing that because the agent had some discretion in planning the raid, the government was completely immune from any lawsuit, even though they terrorized an innocent family in the wrong home. And remarkably, the district court agreed. They dismissed the case. The Martins appealed to the 11th Circuit Court of Appeals, hoping for a dose of common sense. Surely, they thought, the appeals court would see how absurd this reasoning was. Instead, they got more of the same. The 11th Circuit issued a ruling that essentially turned the discretionary shield into an invincible suit of armor. The appeals court's reasoning was essentially the same as the district court's. They reasoned that because there was no specific FBI handbook that said, Step 1, do not use a crappy personal GPS, or Step 2, look at the numbers on the mailbox, the agent had discretion to plan the raid however he saw fit. Even worse, the 11th Circuit leaned on something called a supremacy clause defense. They argued that because the agents were carrying out a federal mission, they were shielded from the kind of liability a normal person would face. This theory essentially argued that because the agents were furthering federal policy, in this case executing a federal warrant to apprehend suspected criminals, they were shielded from state tort law entirely. It was a terrifying precedent. As long as a federal agent is on the job, they can basically ignore the address on a warrant, and as long as they claim it was a judgment call, you are barred from even entering the courtroom. So at this point, the Martin family had been turned away by both the district court and the appeals court. The message was clear. If you're an innocent citizen and the FBI raids your home by mistake, you have no recourse. No day in court, no accountability, nothing. The Martins refused to back down. This case, Martin versus United States, made its way all the way to the marble steps of the Supreme Court. But the Martin family didn't give up. They petitioned the United States Supreme Court to review their case. And remarkably, the Supreme Court agreed to hear it. The question was simple. Can the government use discretion as a get-out-of-jail-free card for basic operational incompetence? Does the discretionary function exception really protect the government when federal agents raid the wrong house and terrorize an innocent family? When the Supreme Court took the case, the legal community held its breath. This wasn't just about one family in Atlanta, it was about whether the FTCA meant anything at all. The ruling came down, and it was a 9-0 unanimous shutout. The answer came down in a 9-0 unanimous ruling in favor of the Martin family. Not 5-4, not 6-3, 9-0. Every single justice agreed that the lower courts had gotten this wrong. In a legal era where the court is often divided 6-3 on political lines, a 9-0 ruling is the judicial equivalent of a thunderclap. It means the lower court's reasoning wasn't just off, it was fundamentally wrong. Justice Neil Gorsuch authored the opinion, and he didn't mince words. The Supreme Court vacated, meaning they completely threw out the 11th Circuit's decision and sent the case back down to them for re-evaluation. Gorsuch pointed out that the 11th Circuit had botched the analysis. Now the Supreme Court's opinion addressed multiple problems with the lower court's reasoning. First, they struck down the 11th Circuit's reliance on the Supremacy Clause as a defense. The court made it clear that you can't just invoke federal supremacy as a blanket immunity shield whenever federal agents commit wrongful acts against citizens. The Supreme Court clarified that the discretionary function exception is supposed to protect policy-level decisions, things like a high-level official deciding which neighborhoods to prioritize for patrols based on crime data. It was never intended to protect a ministerial or operational failure, like failing to read a street sign. Second, and perhaps most importantly, the court essentially told the 11th Circuit, go back and do your homework. They remanded the case, ordering the lower court to take a first principles look at what discretion actually means. The court was essentially saying, you need to look at the history of this law, look at what Congress actually intended, and stop allowing the government to use this exception as a get-out-of-jail-free card for basic operational screw-ups. The Supreme Court effectively struck down the idea that the government can use the Supremacy Clause to hide from the FTCA. This was a massive win for the Martin family and for accountability in general. A unanimous Supreme Court decision carries enormous weight. It sends a clear message about how the law should be interpreted. But as we're about to see, the government doesn't give up its power easily. Even with a 9-0 unanimous defeat hanging over their heads, the Department of Justice is already trying to find a new way to shut the Martins out. But here's the thing. The case isn't over yet. The Supreme Court didn't rule on the merits of the case itself. They didn't say the government is liable and here's how much they owe. Instead, they sent the case back to the 11th Circuit and essentially said, do this again and do it right this time. Now I want to pause here because I know many of you watching are Second Amendment supporters. Why does this case matter to you? It matters because if the government can raid the wrong house with zero liability, then your right to keep and bear arms is effectively under siege every time an agent makes a choice. If you have a firearm for self-defense, like the boyfriend in this case did, and you find yourself in a standoff with people who shouldn't even be on your property, the legal fallout shouldn't be too bad. They had discretion. This case is the front line of defending the sanctity of the home. You'd think a 9-0 unanimous defeat would be enough to make the Department of Justice pack its bags and head to the settlement table. You would think that after a 9-0 smackdown by the Supreme Court, the federal government might reconsider its position. You would think they might acknowledge that terrorizing an innocent family warrants at least allowing them to have their day in court. But in the legal world, the government rarely goes down without a fight. Since the case was remanded back to the 11th Circuit, the DOJ has filed a new response, and their argument is, quite frankly, audacious. Recently, the Department of Justice filed a new response in this case, and in it, they argue that the 11th Circuit should still dismiss the case, should still rule the same way, despite what the Supreme Court just said in their unanimous ruling. Let me repeat that. They are essentially telling the 11th Circuit, look, we know the Supreme Court said the Supremacy Clause doesn't protect us, but we still think you should rule exactly the same way you did before. The DOJ is essentially asking the 11th Circuit to ignore the Supreme Court's guidance and rule in favor of the government anyway. How? By doubling down on the discretionary function exception. The government's central position is that the agent's mistaken entry was the direct result of discretionary decisions. The government's central argument is still the same. They claim that the agent's mistaken entry into the wrong home resulted directly from discretionary decisions about how to conduct the pre-dawn raid. They argue that how an agent navigates in the dark, how they conduct surveillance, and how they identify a house from its external features are all judgment calls. Decisions about surveillance, about how to approach the house in the dark, about how to navigate without alerting suspects, about how to identify the structure from external features, all of these, they argue, were discretionary judgments. The FBI maintains that no statute, no regulation, no constitutional rule, and no binding policy within the FBI dictates the specific steps that agents have to take to evaluate a home and decide that it's the correct target. They are claiming that because no specific FBI regulation prohibits using a personal GPS or mandates double-checking a street sign, the agents were free to use their best judgment, even if that judgment was catastrophically wrong. Think about the implications of that argument. If the government's position is accepted, it would mean that as long as an agent has any discretion in how to execute a raid, the government is immune from liability no matter how negligent, how careless, or how catastrophic the mistakes are. Wrong house doesn't matter. Traumatized children doesn't matter. Constitutional violations doesn't matter. As long as the agent had some discretion, the government walks away scot-free. It is a sore loser defense that attempts to turn the Supreme Court's narrow ruling into a meaningless victory for the Martins. But the Martin family and their legal team aren't letting the DOJ move the goalposts. They recently filed their response, and it's a masterclass in common sense law. The Martin family has now filed their response to the FBI's arguments, and they're not backing down either. Their brief makes a powerful case for why the 11th Circuit should reverse its previous ruling based on what the Supreme Court said. They are arguing that executing a warrant is a ministerial duty, not a policy choice. The Martins argue that the federal government cannot simply hide behind the discretionary function exception to escape liability for what was, at its core, a botched raid of an innocent family's home. There is no policy that encourages raiding the wrong house. In fact, the warrant itself is a specific instruction from a judge to go to one specific address. Ignoring that address isn't a judgment call. It's a failure to follow orders. They point out that the Supreme Court already told the 11th Circuit to go back and take a hard first principles look at what the discretionary function exception actually means. The Martins are pushing the 11th Circuit to adopt a first principles approach, just as Justice Gorsuch suggested. And when you do that analysis, the Martins argue, history and precedent show that the exception only protects actual policy decisions and the implementation of regulatory programs. It doesn't protect basic operational screw-ups by a specific agent who used his personal GPS and ignored the address on the warrant. They argue that operational screw-ups are not policy decisions. Traumatizing a family because you didn't look at a mailbox isn't grounded in social, economic, or political policy. The family makes a critical distinction in their brief. Executing a warrant at the correct address is a ministerial duty, not a policy choice. Federal agents have no discretion to just swap out the wrong home and raid it however they want. There's no policy judgment involved in reading an address on a warrant and going to that address. That's just basic competence. The Martins argue that raiding the wrong home, traumatizing an innocent family, and ignoring the address on the warrant isn't policy-grounded conduct. It's unconstitutional, it's careless, and it's completely untethered from any legitimate federal policy that the discretionary function exception was designed to protect. The FTCA was written specifically for this. Congress created the law enforcement proviso because of wrong house raids just like this one in the 1970s. Once you strip away the discretionary function shield, the Martins argue, this case becomes really straightforward. Under the FTCA, the United States is liable if a private person in similar circumstances would be liable under state law. So the question becomes, if a private citizen broke into someone's home, detonated explosives, held them at gunpoint, and traumatized their child because they got the address wrong, would they be liable? Absolutely they would be. The family's brief asks the 11th Circuit to follow the Supreme Court's direction, reject the government's overly broad reading of the discretionary function exception, and apply the ordinary private person standard. They're asking the court for a simple, fair shot. Let this case go to trial. Stop trying to kill it in the cradle with immunity doctrines and let a jury decide if the FBI was negligent. That's really what the Martin family is ultimately asking for at this stage. They're not even asking the courts to rule in their favor on the merits yet. They're just asking for a fair shot, a chance to present their case to a jury and let that jury decide whether what the FBI did was wrongful. This is where it gets real for us. The 11th Circuit has officially set new oral arguments for the week of March 23rd. As I mentioned, this case is heading back for re-review in the 11th Circuit in light of what the Supreme Court said in that 9-0 ruling. This is the rematch. The world is watching to see if the 11th Circuit will finally get the message from the Supreme Court, or if they will try to find a new loophole to protect the federal government from accountability. So in just a couple of months, the appeals court will hear arguments from both sides and will have to decide. Does the discretionary function exception really protect the government in this situation? Or does an innocent family deserve their day in court after being terrorized by a botched FBI raid? If the 11th Circuit rules in favor of the Martins, it opens the door for every American to hold federal agents accountable for reckless incompetence. If they rule for the DOJ, it effectively signals that as long as a federal agent is making a choice, the Fourth Amendment is just a piece of paper. This case is a perfect example of why we stay vigilant. The Supreme Court's ruling in the Martin case represents a critical narrowing of the government's ability to avoid lawsuits by claiming broad immunity. This case, along with others challenging qualified immunity and government overreach, reinforces a fundamental principle: the federal government and individual agents can and should be held accountable when they recklessly invade someone's home or misuse their power. It's not just about a botched raid, it's about whether the government is a private individual under the law, liable for its mistakes, or a king that can do no wrong. This isn't just about one family in suburban Atlanta. This is about whether we as citizens have any meaningful recourse when the government violates our rights. This is about whether the Fourth Amendment's protection against unreasonable searches and seizures means anything when federal agents can simply claim discretion and walk away from accountability. As Justice Sotomayor noted in her concurrence, it is hard to see how failing to check a street sign is a protected policy judgment. We agree. As this case moves toward those March 23rd arguments, I will be right here to give you the play-by-play. As we get more information as this case develops, I will let you guys know. If you appreciate this deep dive into the legal battles for our rights, make sure you like this video and share it. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe.